We are going to talk about the Citizenship Act for essential workers. So basically, this is the one that was introduced on March 15. But initially, it was introduced back, I guess, 2 years ago. But then this one was reintroduced on March 15, 2021. And the reason we're talking about it is because there has been a lot of behind the scenes actions, and it looks promising. But again, remember, it still has to pass both the House and the Senate in order for it to become law and signed by the president. But in the meantime, there are talks talking about that they really want to integrate this Citizenship for Essential Workers Act in the budget reconciliation. Remember, we have talked about budget reconciliation before, and then it was dead. They said that they can't really go with it into the budget reconciliation. They have to come up with a bipartisan effort. But now it looks like those budget reconciliations talks are going behind the scene as far as Citizenship for Essential Workers Act is concerned. And that is the reason I'm going over the test in detail in order to know really who qualifies and how it is going to play out if this thing becomes law. If this thing becomes law, really it's going to be helpful for a lot of people. But before we go into the details, let me just make two quick announcements. The first one is that the USCIS has been waiving interviews, Green Card interviews for certain applicants. Not everybody. Certain applicants have received this favor to be waived their interview because remember, back under Trump, you had to go to an interview regardless. There was no discretionary measure as far as interview is concerned for green card applicants. But now certain applicants will see themselves their interviews being waived. So for example, VAWA petitioners, sometimes if you have all the evidence, you might not go to the interview. A juvenile petitioner, like special immigrant, employment sponsor type of green cards, and marriage petitions in some instances where the evidence are so obvious. For example, let's say you have children in the marriage and stuff like that. Really, there's no need for interview because those are elements that really validate the marriage. So something to keep. Really, this is a very good news in one way. And then just something to really keep in mind: if you don't receive an interview letter, it's maybe because you qualify for that waiver. If you apply for a green card. Another announcement is we are still trying to get into that 10,000 subscribers landmark or milestone. Help me help you. Let's share my videos and comment, and so that the YouTube algorithm will pick up and we'll get into that map of 10,000 so that we can do those live sessions and at least book 2 days in a row. And I'm thinking it's going to be a certain weekend. We'll do Saturday, Sunday, and we will answer those questions really as much as we can. But remember, if you need a consultation, really, you just have to consider consultation. It's helpful if you really know the details of your case, where you stand. 202-751-2180. Email address in the description box, and consultation fees apply, because I have to keep saying it because some people really forget about that part. So let's get into the Essential Workers Act, basically a Citizenship for Essential Workers Act, the text. And as you said, it says to amend the Immigration Nationality Act to provide for adjustment of status for essential worker and other purposes. That's the goal of the bill when it was introduced March 5th, 2021. Okay. And who is really considered essential worker? It says an alien who satisfies the eligibility requirements set forth in Section B and submit an application and satisfy the criminal and national security background checks and payment of applicable fees pursuant to the procedures set forth in subsection D, and the parents, spouse, sons, and daughters of such alien. Let's say that the person qualifies and they have kids and they have spouses, so those spouses too will be included in the application, and they will be they'll have their pathway up and up for them for citizenship. This is really good. Let's go again under the requirement. Who is considered essential worker? I know you guys have been talking about asking, am I essential worker? Am I an essential worker? This is the people. It's so in detail. At least I'll leave the link in the description box so that you can read if your occupation is listed really. And if you go to my community tab as well, I have put up a link for CDC guidelines when it comes to essential workers. It's also in detail. So eligibility: an alien applying for status under subsection A shall satisfy for the following requirements. Okay, alien working in certain sectors, industry, and occupations, except as provided in paragraph 2. The alien shall have at any point during the period described in subsection I earn income for work in any following private, public, or non-profit sector, industry, or occupation. What type of sectors? In healthcare, emergency response, sanitation, restaurant ownership, food preparation, vending, catering, food packing, food services, or delivery. Even like, let's say you were delivering food during this pandemic, or like an Uber driver or something around those lines, really you are qualified as essential worker as long as you can show proof of payment that you were being paid for that type of job. Hotel or retail, fish, poultry, and meat processing work, agricultural work, including labor that is seasonal in nature, even if it's seasonal in nature, so you will be qualified. Okay, commercial or residential landscaping, commercial or residential construction or renovation, housing, residential and commercial construction related activities, or public works construction, domestic work in private household, including child care, home care, or house cleaning. So some of you guys actually emailed me asking whether you qualify as a housemaid. It is that it's clear now that you qualify as an essential worker. Natural disaster recovery, disaster reconstruction and related construction, home and community-based work, including home health care, residential care, assistant with activity of daily living. So any service provided by direct care workers, okay? Any other provision of care to individual in their homes by direct service provider, personal care attendant, and home health aide. Family care, including child care services and home child care services such as nanny services and care services provided by family member to other family member. This is so important because even if you are just providing help in terms of being a nanny or just basically taking care of other people's children when they're going to work during this pandemic, then you do qualify as well. Manufacturing, warehousing, transportation, or logistics, janitorial, laundromat, or dry cleaning operators. So you are qualified. This is so pretty much almost everybody, to be honest, if you work during this pandemic and you can prove basically your payment. Any other work in essential critical infrastructure, labor, or services. Okay, so and then what are the people who are not qualified? It says an alien not described in paragraph 1, the one that we just listed, shall have earned income in sector and during the period but was unable to continue that work. This part you still qualify even if you earn, but to no fault of yours, and then the job ended in the in the middle of the pandemic, the job ended, not because it's not your fault, you will still be qualified. And you try to resume working, try to find a job, try to work, but you couldn't because you were still working. You was the job ended not because it was your fault, so you will still qualify if you're surviving by a parent, spouse, son, daughter of an alien, your children. Even if, let's say, the person who was undocumented passed away during the pandemic, but they're survived by their parents, spouses, or son or daughter, their children will be qualified, and their parents and their spouses. Okay, so that's about who is qualified. And then we talk, now they're talking about the presence, physical presence. You must have been as of January 1st 2021 physically present in the United States. And let's say you travel from the day of your application. Let's say this bill passes today, okay, but from, let's say, from January 2nd, you were outside of the United States, you went and came back, stuff like that. What's gonna happen? What's gonna happen is, if the absences are more than 130 days, 6 months of absences, if you put it together in aggregate, so you combine all the time you were out, in, and if it's 6 months in total, the person will not be qualified unless they provide really a valid reason, circumstances beyond their control, okay, including the serious illness of the alien, death or serious illness of the spouse, parent, grandparent, grandchildren, sibling, son, daughter, etc. But the thing is, it's going to be discretionary as far as if they will consider your reason. But if you have less than 180 days, less than 6 months outside of the United States from after January 1st, of course, then you should be qualified, okay? So, if you have an effective notice to appear, remember the problem with order of removal and the notice to appear, it says that it should not be considered to interrupt the continuity of alien physical presence in the United States. For those who are not familiar with the physical presence when it comes to cancellation of removal, the day they give you a notice to appear, that's when they stop calculating your physical presence, or they start calculating your physical presence depending on whether your notice of appear was defective or not. So, but in this context, they're not going to take into consideration that part. So I don't want to elaborate too more about it, because we really want to focus on who's qualified and who's not. So now we go into what we consider the ground of ineligibility. So certain ground of inadmissibility. Remember, we have talked about inadmissibility before, and in this context too, they still have to find out whether you're admissible or not admissible, because if you have certain crimes are not waivable, or they're not easily waivable, and those could disqualify a person. But they're talking about here, if it says that subject to subparagraph B, an alien shall be ineligible for study under the section if the alien is inadmissible under paragraph 236E C of the INA 112A, right, has been convicted of felony offenses. So basically, if you Google INA 212 and then you look at those sections, if you are inadmissible on those grounds, you still here going to be inadmissible. Most of the time, those are crimes involving basically like felonies, crimes, stuff like that, like serious crimes, okay? It says, if you have been convicted of a felony offense, you see, excluding any offense under the law for which an essential element in the alien immigration status or have been convicted for 3 or more misdemeanor offenses. If you have 3 or more misdemeanor offenses, unfortunately, you will not be qualified because still the ground of inadmissibility applies. But and then if you have been convicted for felony offenses, still you're not going to be qualified because the ground of inadmissibility applies as well. So, but then when does the waiver come into play? So the waivers come into play, remember, waiver is something that you ask for forgiveness so that you can get a forgiveness, so you can adjust status. So if you're inadmissible, that's when people apply for waivers. So in this context of Essential Workers, Citizenship for Essential Workers Act, the question becomes, do waivers apply? Yes, of course, waivers still come into play, but under what condition? Let's go into it. So it says waiver of inadmissibility under subs paragraph A, C, and D of section 12A2 and BBB paragraph 6E, 8, 10C, and 10E of such section. Waiver ineligibility under those paragraphs, excluding offenses described. So basically what they're saying is that if you have felony and 3 misdemeanors, unfortunately they're not going to waive it. But in certain cases they could consider waiver. For example, they say if you have 1 misdemeanor offense, if during the 5-year period preceding the date on which the application applied for status under this section, the alien has not been convicted of any offenses. So let's say you just have 1 misdemeanor for the past 5 years preceding the date you apply, then waiver will be considered for you. So they will waive that for you. Another thing is if you have 2 misdemeanor offenses, if during the 10-year period proceeding you have not committed another misdemeanor offense, then they can waive that for you as well. So in making consideration, they will look at the severity of the underlying circumstances, conduct or violation, the duration of alien residence in the United States, evidence of rehabilitation if applicable, and the extent to which alien removal or denial will adversely affect the alien of the alien United States citizen or lawful permanent resident family members. Let me explain this one. So there is what they call Citizenship for Essential Workers Act. That's for adjustment of status. But remember that even though they're giving this thing to people, let's just assume that it has passed, okay? Then people can adjust status. They're still going to revert back to the rules when it comes to adjustment of status. They're still really going to find whether you're admissible or you are not admissible. And once they determine that, then they look at the waivers. What type of inadmissibility can be waived? That's what I'm trying to say. And if you have felonies or 3 misdemeanors, unfortunately, it's not going to be easy for them to waive that. But lesser crime can be waived. For example, if you look here, they say 1 misdemeanor offense during the 5-year period preceding the date on which you apply, provided that you're not being convicted for another one, right? And then 2 misdemeanor during the 10 last years, provided that you have not convicted another misdemeanor. And then when they decide, they look at all those criteria here, 1, 2, 3, 4, to decide whether they can waive that for you and you can adjust status. So I think I made myself very clear. And then alien in certain immigration status, alien shall be ineligible under the section if on January the alien was any of the following. So who's not going to be qualified? If as of January 1st, 2021, the alien was lawfully admitted for permanent residence. basically, let's say you got in the US on January 1st, 2021 with a valid visa, and then 3 months later your visa expired, you're not going to be qualified, because in order to qualify, the person must have been undocumented as of January 1st, 2021. They're just repeating the same thing, basically. If you've been admitted as a refugee or granted asylum, you're not going to be qualified for this one, because really you have been granted asylum already. Why would you apply for this one? This one makes sense. And C, an alien who, according to the record, was in a period of authorized stay. That's what I'm saying. So you came on January 1st, 2021 with a valid visa, and then later on the visa expires, you are not going to be qualified, because at the time of January, as of the date of January 1st, 2021, you were really lawfully here. So this is for people who have been unlawful as of January 1st, 2021. So the spouse, son, daughter who's eligible started under the section. It can go on and on. Just turn a non-immigrant, an alien parole into the Commonwealth. And then if you came, you are outside of the United States, and then unlawfully re-entering the United States, you're not going to be qualified. Basically, you departed as a subject of order of exclusion, deportation, removal, or voluntary departure, and you were outside of the United States as of January 1st, 2021, and then re-enter unlawfully after January 21st, 2021, you're not going to be qualified. Basically, let's say, because some people, one of the reason, not the entire reason, you just hear me first. One of the reason we have a lot of surge at the borders recently, it's because when the Biden administration came up with this announcement that they will have a more humane immigration reform, people were rushing at the border because they were hoping that they will get here and then get benefit from those bills. But unfortunately, they are not going to be benefiting from those bills, because they were outside of the United States as of January 1st, 2021. And then let's say you try to re-enter just because you thought you could benefit, that person as well will not, because re-entering unlawfully, you're not going to be benefiting from this one. Even if you departed voluntarily, you're not, because as of January 1st, 2021, the person was not in the US. Okay, let's move along. As far as fees, how are you going to pay for it? They have installment plan as well. You see installment. This is the first time really that when they're forgiving, because this could be considered as an amnesty. Usually people pay penalty fees, but for this one, they are trying to, you can make arrangement to pay those fees, those penalty fees, because the application will have its own fees, not to mention the fees for the penalty for unlawful presence. So basically, they are going to allow people to make installment plan. Okay, and it says again, exemption applicant may, in discretion of the secretary, be exempted from paying. As a matter of discretion, the secretary might exempt somebody from paying the fees. Okay, if the person basically under if you are under the poverty federal poverty guideline, 250% less. Okay, you're younger than 21 years old, foster care, you cannot care for yourself because of serious disability, those are the people that will not be required to pay those fees. Okay, and then okay, and then that's, and here really it's not a big deal, somebody can just read it, nothing to really explain here. Well, as I wanted to to reiterate here, so yeah, as far as removal proceedings, some people are in the removal proceedings when they're applying for, let's say this bill passes, okay? And people who find themselves in removal proceeding, if the application your application for this one get approved, then what's going to happen, the judge should vacate, the attorney general shall vacate the order of removal and terminate any removal proceedings. This is so great. Remember, sometime when we talk about people terminating their removal proceeding, you have to give a valid reason, because let's say somebody asks for asylum and now they find themselves in removal proceedings, and later on they get married, trying to adjust status under marriage, but still their case is still there because they're the one who claimed asylum, right? Fear of persecution. And in order to terminate that, even after you have acquired your residency, you still have to provide them with good, valid reasons. But in this case, what they're telling us is that once the application gets approved, they are going to immediately terminate any removal proceedings that is into any removal proceeding that is going on is going to be terminated immediately after the approval, okay? And then you're now required to file a separate motion to reconsider if your case has been closed. It's just going to be automatically, once you get it, just everything over there is closed once you get this approved. This is really important, and that's what I wanted to reiterate. And what else? And then this one too important, employment authorization under this section. Let's say you apply, the employment authorization should be issued within 30 days, okay? Pen the removal stay, so basically the employment, once, it's basically simple, right? You apply and the case is pending, then within 30 days you should be issued an employment card, like you should be able to work, permission to work. And what else? Yeah, and then the employer has to accept that even though your case is still pending, it's going to be law once it passes. And then that's it, right? Pretty much. And here talk about appeal. If you the application gets denied, you can still appeal it, I believe, right? Yeah, 90 and beyond. Yeah, the appeal shall be filed no later than 90 days after the date of service or denial, okay? So I think, yeah, I think that's the main thing. And then here it talks about expungement and sentencing for people under those are case by case basis. If you have some type of felonies, how are you going to get those expunged? Petty offenses, it's really just case by case basis, and that's something you have to talk to a lawyer once you're applying for this, once it becomes law, because if you have certain crimes and want them to be erased, there's a procedure to follow, okay? So that's it. That's what I wanted to talk about today. I'm gonna leave the link in the description box so that you can go ahead and read it. I pretty much highlight the important thing that someone should know in case this bill passes. And this bill has a lot of support, a lot of talks behind the scene as far as whether they should integrate this under budget reconciliation, or whether they should convince the other parties to just go ahead and pass it. And some people have been talking about 11 million individual, but the thing is, if you happen to be under those 11 million individual and happen to be working during the pandemic and can prove it, then you should be considered an essential workers for the purpose of this bill. So you don't have to wait for the separate 11 million individual bill to pass in order for you to apply. If this one passes and you happen to be an essential worker, then you qualify. Really, doesn't matter if you they're counting 11 million, but basically if you go with those requirements alone and you happen to be essential worker, and the list is very long, so most people should be qualified, right? And we know that people don't have work authorization. They'll say, well, I wasn't working because I didn't have work authorization. But let's say you were working under the table and you can prove that you had you've been paid during the pandemic, that will work as well. Okay, Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. This was US immigration. Go ahead, share, like, don't forget to comment. Remember that we are still going to reach that 10,000 subscribers so that we can at least give you the privilege to ask questions, and we will do our best to answer them. As long as they're not too specific, we will try our best to answer those questions. Okay, we'll really help us help you. That's really what I wanted to say. It is Sunday. Happy Sunday, religious workers. Don't forget to check out my video and apply under religious worker if you just went to church really and working there. You should benefit for that as well. Okay, and that's it for today. Hope to talk to you soon. Bye bye.